Coming our way next, we have Business and Immigration Law Update. This is a presentation of the Khurana Law Firm located in Rockville, Maryland. Here, the head attorney at law is none other than the famous Mr. Ramesh Khurana. This week, Attorney Khurana is alongside Dr. Rajesh Nandan Mehra, and they will fill us in on the eligibility for naturalization, or rather, U.S. citizenship by application. Let's join them in their discussion.
Good morning. This is Dr. Rajesh Mehra bringing you an immigration update. I'm honored to have in our studios Attorney Khurana from the Khurana Law Firm in Rockville, Maryland. Welcome, sir.
Thank you very much, Dr. Mehra, for inviting me to your studio.
Good, good. The weather has moved on. We're into the warmer months now, and everybody's out enjoying life, and here we are working, right?
That's very true, Dr. Mehra.
But then somebody has to do this, right?
That's right.
Okay.
That's why you and I work very hard.
We work very hard.
Everybody works very
Everybody
hard.
does.
Yeah,
You have to. You have to do what you enjoy.
Exactly.
I say I've been practicing medicine for 30 years, but I haven't worked in one day. So
yeah, because that means you are so much passionate about your job.
That's right.
So
it does not look like work.
Exactly.
That's the secret. Anyway,
Yes.
so we've been covering a lot of health, health is on my mind. Health topics, no, immigration topics.
That's good for us.
That's
good
right.
for lawyers also.
Yeah.
If we are healthy, we can work more.
You have
right?
to. That's right. So a lot of immigration topics: H-1B, L-1, A and B, visa, green card, labor certification, so many things.
How do you remember, Dr. Mehra?
See, you're training me right.
Oh my God, you
That's
remember
right.
all these concepts.
All these concepts. So now, please explain the condition for continuous residence in the United States, and are there separate conditions for spouses, especially at the time of marriage?
You see, Dr. Mehra, we talked about H-1B, we talked about L-1s, then labor certification process. So when a person comes over here, especially when we are talking about employment-based category, you start from non-immigrant visa, and then you move to an immigrant visa. Your green card is called an immigrant visa.
Right.
So that means you have immigrated to the United States.
Correct.
Now, I'll pick up from here. So when you have been holding your immigrant status, which is popularly called the green card status. So if you have been holding your green card status based on your employment category for the last 5 years, you become eligible to be naturalized.
Got it.
Now this naturalization is a process. You know, you must be wondering, what is this naturalization, what is citizenship?
Right.
So naturalization is a process when you file your application based on your 5-year life of green card. This is processed by the USCIS, and if you are found eligible based on certain criteria, you get your citizenship. So you get naturalized.
Right.
So this is based on employment. But if you marry a US citizen, so at the time of marriage, your spouse was a US citizen, then you become eligible to apply when you complete 3 years instead of 5 years.
I see. Just speeds up the process.
Yes, it speeds up the process, but there are certain conditions to be satisfied. Number one condition, you should continue to be married when you are applying based on 3-year green card status. So you are continuously married with the same US citizen.
Person.
It's not like you divorced one US citizen and you got married with another US citizen. No, you cannot get the benefit of 3 years.
Got it.
If you are continuing to be married with the same US
person.
citizen and you are living together. When I say living together, that doesn't mean that if your job situation doesn't permit you to stay in Maryland or Virginia and you are staying in New York, but every week you are meeting, right? Then you satisfy that condition.
You do satisfy.
Yes.
Okay.
Another thing is, when I'm saying 5 years or 3 years, so you can apply 3 months before completing your 5 years or 3 years. So the hope is the processing time usually is about 4 months to 5 months. So when you are interviewed and your application for citizenship is approved, by the time you would have completed 5 years or 3 years. So people who want to really move very fast, especially we saw recently when elections for the president office were being conducted, many people wanted to become citizens or they wanted to be naturalized. So they were filing 3 months before completing 5 years or 3 years so that they could get their citizenship on time to vote for the president election.
Got it. Interesting. Now, when can a person reapply under the continuous residence in the U.S. if something happens?
Yeah. You know, Dr. Mehra, because we had talked about physical presence in the United States. So when we are talking about 5-year line, you have to be present physically in the United States for 2.5 years. And at any point of time, you should not be going out of the United States for more than 180 days. So, in fact, sometimes people get confused. If they are going outside the United States, they take re-entry permits. So they would say, I'm going to return after 1 year, after 2 years, because re-entry permit can be granted maximum at a time for a period of 2 years. Re-entry permit is a different concept altogether. But when you are talking in relation to obtaining citizenship, you cannot afford to be away for more than 6 months. Otherwise, your continuous stay is broken. So if you stayed in India, let's say you are of Indian national, you stayed in India for 7 months, so you broke your continuous stay. But here, this is rebuttable presumption. If it is just for 190 days or more than 6 months, so you have to provide evidence that
Why
you are,
did that?
yes, exactly. Like your intent was not to abandon your residence in the
US.
United States. To give you an example, husband and wife, they are living together, they have bought a house. Husband goes to India because his mother is sick, and he remains in India for an extended period of time, let's say 7 months. So he files his tax returns here, his wife is here, his children are here, he has his bank accounts, everything is here. So for a person like him, probably I would think it would be much easier to overcome that burden, that I did not intend
Abandon.
to leave United States for an extended period of time. But if you stay outside United States for more than 1 year, definitely
That
your
would be
physical
hard.
stay is broken.
Right.
So in that kind of situation, so when you say, you know, what's the other time? So it's 4 years and 1 day, because eligibility is 5 years, right? If it is employment based. And if your stay is broken because you stayed in India for a continuous
year.
period of more than 1 year, then that stay is broken and you apply after 4 years and 1 day. Now similarly, if you are married to a United States citizen spouse and you stayed outside the United States for more than 1 year, then you can apply after 2 years and 1 day. Because eligibility is after 3 years, right? So
Because of the spouse.
yes. So you have always to keep in your mind that never try to stay outside the United States physically if you are not a naturalized citizen. So far you are on a green card status.
More
and
than maybe a couple of months, right?
yes, and waiting to become a US citizen. Don't let your stay exceed 6 months, because then you have to provide a proof that you didn't like to abandon your residence, and more than 1 year, definitely
Don't forget,
you have to wait for 4 years and 1 day.
How about moral character? Does that play into this? What you've behaved like, what your driving record is? Do you have domestic violence charges against you?
Yes, Dr. Mehra. The eligibility criteria for being naturalized includes moral character as well, which is one of the very important factors. And USCIS would like to make sure that a person who is applying for naturalization is a person of good moral character. And especially they look at the statutory period. When I'm saying statutory period, if a person is eligible to be naturalized after 5 years. So the statutory period goes back up to 5 years. And if a person is eligible to become naturalized after 3 years, the statutory period is 3 years. So they look at the statutory period, they look at your record, and if you are not having a clean record, then of course you are subject to questions. Then you have to provide all court papers, arrest records, and explanation, what was the disposal. Not that a person who has a criminal record make that person automatically ineligible. You know, I have seen in my practice, if there is just one DUI without any other charges, so that person, if it is beyond statutory period, it's not that difficult to overcome that kind of situation. Even within statutory period, if he was a first offender, it was first time that he was charged with DUI and convicted, we have been able to overcome that kind of situation. But again, it's basically fact specific situation. So we have to look at the charging document and court disposal, and then we advise the client like what we expect here. So yes, it's very important, that a person
maintain some good character.
He is a person of good moral character. It's very wide, and all other factors can be satisfied. USCIS officer is happy, yes, but if you think that you are not a person of good moral character, he can deny your application.
Reject the application.
Yes.
Right. Now, what about the English and the civic test to obtain naturalization? Are there any waivers for this requirement?
Yes, Dr. Mehra. Now, first of all, a person who has met with the eligibility requirements like physical stay and having stayed in the same district where you are applying for the last 3 months, and you are a person of good moral character, then you have to pass the exam, English exam and civic test. Now, civic test would include knowledge of government and history. Now, there are waivers. Let's say a person has some mental retardation or that kind of medical condition. He goes to a psychiatric or a psychologist, now who will make an assessment of that person if he has that kind of problem. So he will prepare a detailed report. We can take a waiver for that person. He doesn't have to take English or civic test. And likewise, a person who, let me say, he has completed 50 years of age, and he has been holding a green card for the last 20 years. So he can be waived from the requirement of English test. And 55 years of age, then if he has been holding 15 years green card. And likewise, a person can be waived from the requirement of passing civic. I would not say civic stringent requirement is diluted if you can answer 10 out of, let's say, 25 questions. So if a person is over 65 years of age, so then he can answer those questions even in his own language, because English requirement is waived. So these kinds of waivers are available.
Some exceptions.
Again, these are fact specific. You have to talk to an immigration lawyer who will go your documents. He will sit down with you and then advise you accordingly.
Properly.
Yes.
Excellent. Well, I know that you're very busy, but it's an honor to have you spend time with our viewers, educating, recommending, and coming up with these great tips. Thank you so much.
Thank you so much, Dr. Mehra. It's always a great pleasure being with you.
Thank you.
And thank you, audience. Again, I would like to request you, talk to your immigration lawyer if you have any questions. Thank you so much for being with us.